Yeah, yeah, yeah. So many lies that you hear from the net, they don't get her respect. She reporting the truth, not a check. You want an unbiased opinion straight from the chest, not a bit of accomplice or someone here for a check. Tune in, these are thoughts from a lawyer on a mission who goes so hard it's like she works on commission. Trolls in the comments might say she tripping cause they lack the knowledge, they don't know they missing. Got a couple current events that you like, wanna know about law from the eyes. Tired of all these blogs running lies because they agendas are disguised. Tune in to the intellect, cause I'm sure y'all missing all the facts of the case that she steady is gifting. Someone here for the people, man, it's so uplifting. If you ain't subscribed yet, then you just omitting facts.
Hello, everyone. It is Pam Esquire, also known as Your Law Intellect. Please hit your like button on the way in. I had an update on the Kelly Bryant case. That is the woman who is accused of leaving her kids in the most filthy house ever over there in Pontiac. And today she had some court appearances, and one of those is her motion to reduce her bond. As I said in the last video, if you guys have not watched that video, please make sure that you go watch it, and I'll make sure that it's linked to this video if you don't know what I am referring to. It was inevitable that there was going to be a motion to reduce the bond because that first judge hit her with the 1-2. Okay, was like gave her probably the highest bond that I've seen. So, yes, her attorney did a motion to reduce bond, which was anticipated. I told you guys that, and that hearing was actually today. And so, right now, before I leave, I was actually on my way up out of this house, and I said, well, let me go on before I get so caught up that I forget to do the follow up. So, for those of you that end up watching the replay, because I'm going to get right into it, welcome. And again, subscribe to the channel. Thank you so much, Miss Buckeye, for gifting 5 memberships. I appreciate you. I appreciate all of your support over here at this platform and also the support that you have given over on my dad's platform as well. She is the most faithful member over there at World Faith Ministry. She always there. Miss Buckeye, save, because she over there before I get there. I don't even know he's on half the time. But she knows he's over there, and I appreciate that. But all right, I'm about to start playing this video. I hope you guys don't miss too much coming in too late, but I'm just moving and grooving. So let's see. Let's get into it.
Number 250216FY.
Good afternoon, Your Honor. Kanika Ferenczi on behalf of the people.
And good afternoon, Your Honor. Cecilia Caranago up here on behalf and with Kelly Bryant. She is present from the Oakland County Jail on Zoom, and we have no objection to Zoom, Your Honor.
Thank you, Ms. Bryant. Would you state your name for the record, please?
Kelly Bryant.
Thank you. This is the time and date set that the court scheduled for defendant's motion to modify the bond and for a reasonable bond. Ms. Carandongo, you did submit a supplemental pleading. And just to clarify, it references a letter to the court. There was only one letter that you submitted, correct?
Your Honor, this morning, so I obtained a letter from a community support that was sent in a separate email to the court, not into the court file. And then there was also a letter in regards to the medical condition that my client has that was set separate. So there should be one handwritten. Okay, perfect. Yeah. All right. Yep. Okay.
Ms. Ferenczi,
yep, there was just the one.
Ms. Ferenczi, you received those as well?
Yes, Your Honor. I received all those documents this morning.
All right. At this point, the court is prepared to review the items that I had mentioned on the prior date, which were those things that I will address or attempt to address, the factors to determine which pretrial release option is appropriate and under what terms and conditions. I had indicated on the prior date, I'm looking at the defendant's, if any, prior criminal record, any record of appearance or non-appearance, any history of substance abuse, mental condition, the seriousness of the offense charged, the employment history, any financial history as it relates to ability to post bail, the availability of a responsible member or members of the community who would vouch for and monitor the defendant, any facts showing community ties, family relationships, also the length of residence, and any other factors bearing on the risk of appearance or danger to the public. Ms. Kirandongo, anything you wanted to add that the court did not already have at arraignment?
Well, at arraignment, I think pretrial services verified Ms. Bryant's information, but quite frankly, I mean, many of the things that were put in the motion and the supplement were that was added information. I think the court was somewhat concerned about being able to verify the information. I attempted to do that. In the supplement I submitted to the court, I listed all of those factors that the court just mentioned on the record, and listed, I guess what's favorable to my client and what's not, and also how that information was verified. So if the court would like me to, I can go through, those factors, again, as I had mentioned before, both at arraignment and I think also in the first written motion and then in my supplement. I think for Ms. Bryant, we all know the court can't deny bond, so I think everybody's agreeing with that. And then it comes down to whether, essentially a cash bond is appropriate at all, or if it should be a recognizance bond with some type of conditions. And I know the people, will argue that it should be a cash bond. My position is that the only time that the court could do a cash bond is if the court finds either that she's a flight risk or that she poses a danger to the community at large. If the court would like me to, I can go through all the factors that I mentioned and
Let me interrupt you, Ms. Kirandongo, because one of the main things that was of concern at arraignment was the lack of a stable address for Ms. Bryant. That was one of the things that was the focus of the arraigning judge.
That's correct, Your Honor. And Ms. Bryant has a stable residence. She had a stable residence before that, her arrest as well. Now, of course, there's additional concerns because of the publicity that this particular case has received. So Ms. Bryant would not, and I did provide also, I think prior to the last court hearing, the court with the address. And I indicated also who resides at that address for the court. I'm very concerned about putting any of that on the record, given, the kind of posture of this case. But that is with a family member who has also lifelong ties to the community. So Ms. Bryant does have a stable residence to go to. I have also spoken, to other family members, and I spoke to the person who provided a letter to the court, who is also a pillar of the community. Every one of them are willing to, to supervise and I shouldn't say, vouch, but make sure that Ms. Bryant gets to court. And I think, a tether could also assure all of that. The court would be aware 24/7 where Ms. Bryant is. So she was not transient. I know the previous judge made some statements that Ms. Bryant was transient. She was absolutely not transient. She was staying at a residence and had stayed there for quite some time. That is not a residence given the circumstances as they are right now that she would be returning to, and that is mainly due to the amount of publicity that this case has received. So of course now there's new concerns, but she absolutely does have a residence to return to, and I don't believe she was ever transient, Your Honor.
All right.
And I don't think there was any evidence of that either, quite frankly.
All right. As to residence, Ms. Ferenczi, is there any comment?
Yes, Your Honor, I would like to address residency, and then because I only received the supplemental motion this morning, I would like to respond to much of what was documented in that motion, Your Honor.
Okay.
But in regards to residence, what the people find troubling is that the individual that the defendant is being asked to be released to and reside with isn't the one that wrote the letter. That individual is not vouching for her, and I don't believe that that individual has appeared in court and is willing to provide that voucher to the court. That is a concern, and it actually speaks to the high level of instability for Ms. Bryant. A lot of the statements about her transient nature is in conflict with what she told police when she was interviewed. So I do find it troubling when the information is, at times it feels like it's self-serving for Ms. Bryant. I'm happy to address the other issues though, Your Honor, in the supplemental motion.
Your Honor, may I address that particular point that Ms. Parency is making? So I will just tell the court, as an officer of the court, I've spoken to many of Ms. Bryant's family members. And here's the reality of things. The children, you know, I think everybody has now known where the children are. And so the children are with family. And so it becomes a very difficult balance as far as, you know, supporting, sending letters. I had conversations with the individual whose address, you know, was offered as a residence, and that individual wanted to talk to Ms. Bryant too. There are issues with setting up, you know, phone accounts for the Oakland County Jail and actually establishing that communication, to be frank with the court. I spoke to that individual about a letter when she spoke to me, and again, this is, you know, as an officer of the court, when she spoke to me, she was absolutely willing to provide that letter, but there was also just a very short amount of time in which to accomplish that, and she had requested to speak with Ms. Bryant first on the phone. And it's my understanding that there was no previous, you know, account set up for that, and there was 2 days to do it. So that's the reality of it. So it has nothing to do with the person not being willing to vouch for her. That person indicated to me that she absolutely would supervise Ms. Bryant and make sure, you know, that she comes to court. But again, and I think that's the concern for the court, is that the court would like someone to say they're going to make sure she comes. And that brings me to some other things I put in my motion, which I don't think the people are disputing, that this young lady,
let me stop you for a moment, because on the issue of where she will be staying, the court needs to be convinced that this is a stable residence if there are any modifications to the bond where there's a potential that she could be released. I understand the nature of people being hesitant to come forward given the amount of publicity, but the court has to be convinced that Ms. Bryant would return to court and also that she will not be a danger. So go ahead, Ms. Tirandano.
Yes, so in regards to the return to court, Your Honor, which goes to the flight risk portion of, you know, the bond factors that the court can consider, Ms. Bryant has no criminal history. So there's no history of her, you know, appearing or not appearing in court at all, which means she has no history of failing to appear. She, and this information was verified by pretrial services. In addition to that, Ms. Bryant, and this is in the police report, so I don't think this is something that will be disputed by the people. Ms. Bryant, when she was contacted, so she was contacted by the Sheriff's Department and the officer in charge of this case in regards to this case once the children had been located, and she paid for a Lyft ride to the Oakland County Sheriff's Office to turn herself in to talk to the officers. I've been in practice for a number of years now, and I don't think I've ever had a client who actually paid for a share ride to go turn themselves into the Oakland County Jail, and she did that.
So it might be simpler if I go through the issues that I don't believe are in dispute. One, the fact that Ms. Bryant turned herself in after being contacted. I don't believe that that is in dispute.
It's not, Your Honor.
That's correct, Your Honor. The only issue that I would argue that is in dispute, her ability to cooperate with law enforcement.
Understood. Let me finish going through the items that I'm looking at. There is not a prior criminal record.
We do not dispute that.
All right. There is no record of prior non-appearance or flight to avoid prosecution.
That's understood, yes.
Okay. So the issues that the court needs to hear about are, and the court is already aware of the seriousness of the offense charged, and that is certainly something the court will be taking into consideration in modifying any bond. But we have not heard regarding the employment status, financial history as it relates to an ability to post, ties to the community, ties to family members, and the residency is still an issue. So Ms. Kirandongo, if you can address those matters.
Yes, Your Honor. So in regards to the personal circumstances, which I think addresses many of those issues, Ms. Bryant does have a mental health diagnosis. This is reflected in the police report. And I'll tell the court I did submit a subpoena for her records for CNS, which I noted in my supplement that that's where she was going. I gave the court the name of her case manager for treatment too. It's not enough time to get those records, but this was noted. I also believe it might have been noted in the pretrial services report.
It is
right now. I believe so, and that information was verified, I believe, by her father. So she wasn't receiving any medications, but she was receiving treatment. In regards to her physical health, which is one of the other considerations, I did provide the court with a letter that indicates a medical diagnosis for which she's supposed to be receiving infusions. The jail can't accommodate that. Ms. Bryant also was scheduled to have surgery, which that time has passed, but she has issues with which could be internal bleeding that was supposed to be addressed via surgery, and she hasn't been able to have that surgery. I again submitted a subpoena for those records. It's just simply not enough time for St. Joe's, but I did provide as much information as I could to the court on that. Ms. Bryant also, she is a lifelong resident of the city of Pontiac, which that was verified, I believe, by pretrial services. I also believe that the community support letter that I provided to the court indicates that that person is a resident of the city of Pontiac and has known Ms. Bryant since she was 14 years old. Also, her information in regards to being a Pontiac resident was verified by her father through pretrial services. I don't think there's a dispute that Ms. Bryant has lived in the city of Pontiac her whole life. She went to school in the city of Pontiac, and she's never left the city of Pontiac. So that indicates that she has strong ties to the community. I also believe that both the community support letter and also pretrial services, as well as information in the police report, indicate that she has family in the area. Her parents are here. I also indicated to the court that she has siblings in the city of Pontiac. She again has community support, which is not family, but longtime family friend, who appears to be an upstanding member of the local community, who provided a letter to the court indicating that she was in support of Ms. Bryant. So she absolutely has community support. Again, it's a very difficult situation. So when I say community support, I want everybody to understand that that shouldn't mean that, we should be worried about the children, because everybody has made the children a priority. So I just, want the court to know that. But Ms. Bryant absolutely does have a lot of support in the community. In regards to substance abuse, there's no history of substance abuse for Ms. Bryant that I'm aware. It was not noted in any of the reports, and she has not indicated to me that she had.
I'm sorry, I have to pause real quick. I like to go through this, but how does she have support in the community? But how does she have support in the community? However, nobody knew that these kids were living in a house by themselves in a filthy house. And people are allegedly saying that they would ask about the kids, but she would say they were at somebody else's house and they hadn't seen them in a couple of years. And the parents and the dad, I guess, got out of jail for one of them, tried to get the kid and she wouldn't let him get, it just seems a bit contradictory to me, but I can totally see that she did have you can't be okay to even do this, which means your community that you're saying you have knew that you were not okay, knew you had some mental health issues. And it's not to say just because you have mental health issues, you cannot be a productive citizen or be, quote, normal, or be able to function. That's not what I'm saying. But clearly she was not taking whatever medication. And if she was in treatment, she was not following the treatment protocol, because how do you think it's okay to have your kids living in filth to the point where their toenails, they can't even walk out of the house? Because that's how long they are. They can't even walk. To the point where they don't even know how to flush toilets. They don't even know how to clean up behind themselves. The only thing they know is their belly is hurting and their growling is going in their back. And so now they're calling you to try to get food. That's it. To the point where they are has Stockholm syndrome, that they have cell phones and don't even know that they should be calling for help. But you got a community. That, it just seems contradictory to me. But anyways, that's exactly who she looks like right now. So that's why I said, fellas, she was looking real different over there on those Facebook and them Instagram posts and them pictures when she was out at the club. And I'm sure a couple of them guys got her number. She got kids. She got what, like 3-4 kids? Because one of the kids were with their father already. All right, I'll try not to interrupt, but I get it. This is what you have to do, is what your job is, But and that's cool that she went and she turned herself in, and she's never in her 5,000 years of practicing seen anybody do a ride share. And I know a lot of people that have turned themselves in. How they turned them in, I guess she's trying to say the fact she took a ride share or took a Uber in order to turn herself in. I would surmise that she didn't really have much of a choice, because whoever she was living with is not going to get accused of harboring a fugitive and catch a case. And then where else she was going to go? She definitely couldn't go back to the filthy house that they put the yellow tape around and the orange notice on the door that it was hazardous. So where the hell else she was going to go besides try to get this over with? It's probably the only place she had to stay at this point was the jail.
A history of substance abuse or substance use, even marijuana or alcohol. So I don't think that is something that should be of concern to the court. But again, if it was, the court could order her into testing to ensure that she's not using any illegal substances. That's a pretty standard condition of bond. Ms. Bryant also submitted, in regards to income, Creator Services report did note her past history of employment. I noted in my supplement that she was also, prior to her incarceration, she was employed. She was paid through the state of Michigan. I could not obtain that information because it's confidential information, and it was something that was shared with me.
She was employed through the state of Michigan. What was she doing? Now I want to know what she was doing, and she received a check from the state of Michigan that wasn't just a DHS type check. So she was employed with the state.
A few days ago, so I was not able to obtain verification, but Ms. Bryant did inform me of who the person at the state of Michigan that was responsible for her was, and she provided me with that name. Unfortunately, it's a very common name within the Department of Health and Human Services, so I was not able to obtain specific information. She does have a pay stub. It's at the residence she was at. I made contact with the person who resides there. They were trying to locate the paperwork for me, but they were not able to locate it as of yesterday evening at 9 p.m. But she was employed, taking home about $800 a month. So that was what she was making at the time she became incarcerated. That amount of money a month would still make her indigent, which she's already been found to be, which goes to her ability to post a monetary bond. Oakland County appointed her an attorney because she didn't have the funds to hire one. So I think, but she did have employment, which is also something that ties her to the community. I just think her employment would not be enough, to post a monetary bail. Don't believe there's any family members that have funds. Like I said, they're all caring for the children, and that's financially stressful too. nobody has money to post bond for her. At this time, I don't believe.
So $800 a month, she must have did something perhaps maybe through like Michigan Works, which is like when you're on aid, and I'm speculating, perhaps they have some type of programs or something you can go through where you maybe work with somebody, because $800 a month really isn't much money. But now, as you see, the attorney is saying she doesn't have anybody that even has money to help her get out on bond as well. This is some interesting information. And the attorney doesn't have a lot of this information at her disposal because she didn't have it for this hearing that happened this morning.
The employment history, what was disclosed to pretrial services, was verified. Again, it appears that her father verified that information for pretrial services. And some of the other employment that she had was also, verified through the family court case. There was discussions about that. I'm not entirely sure if Ms. Ferenczi was on there when that took place, but it is also information that's been provided to the Department of Health and Human Services. The risk to the community, that's one of the factors the court must take into consideration as well. And again, the chance of her reappearing, I wanted to just address that briefly. The court could address that by placing her in a steel cuff tether that she can't remove from her leg. The court would be aware at all times where she is. If she failed to appear, the tether would indicate where she is. But again, Ms. Bryant turned herself in and actually was inquiring, and I think the people would agree as to the charges she was facing. She knew she was potentially facing serious charges. She's aware. I've met with her probably 10 times at this point. She knows what she's facing. I don't have any reason to believe she has nowhere else to go. So she's a Pontiac resident. She's been here her whole life, and I think if she wanted to flee the state or go somewhere, she'd have done that, already, I think, because she was again not apprehended.
So I'm going to allow the prosecutor to respond to what you have said so far, but
sorry.
I will change a couple of things or modify. You indicated that pretrial services had verified her employment. That's not what the report reflects. It reflects that the defendant reported she had been unemployed since August of 2024. No sources of income were reported. Prior to that, she indicated where she had been working for about a month. So I realize that you are saying you have not had an opportunity to get all of that confirmation, but that you have been seeking it. Ms. Ferenczi?
Thank you, Your Honor. Your Honor, as the court has already noted, the allegations and charges in this case are very serious. Defendant, as the court is well aware, is being charged with 3 counts of child abuse, first degree. And there is a very high likelihood of conviction. The people are happy to provide any facts or evidence if the court would like to hear it. And the initial guidelines call for significant jail time. Your Honor, as I already indicated, the people do not dispute that Ms. Bryant turned herself in and that she cooperated with law enforcement. But as the court is also aware, that does not equate any sort of assurances that she will appear in court. In regards to the mental health diagnoses, and that she was being treated by CNS. There's no proof of a diagnosis, nor were any dates provided to confirm that this is accurate. The people at this point do not believe the defendant is a reliable source of information. She has a history of concealing and deceiving. That is what we have here, Your Honor. And without any sort of proof, I do not believe that the court can use that as accurate information. In regards to defendant's physical health, again, there was no verification of this medical condition. What was provided was a treatment plan from the clinic at Oakland County Jail. And it seems like she is receiving that treatment that is necessary at the clinic. The clinic deems is necessary. There was an additional allegation that the defendant needed transfusions and a possible procedure. Again, not supported by documentation. But Your Honor, regardless of that situation, I would be hard pressed not to address the reason why we're here today. The reason we're here today is because defendant did not provide her own children, the victims here, with basic medical care, basic needs for years. And this irony of her condition right now is not lost on me. And it seems like she can and is being treated appropriately at the clinic at the county jail. Your Honor, in regards to Ms. Bryant's employment history, again, no proof was provided about her employment status. And as the court has already highlighted, the information that was provided has not been confirmed in the pretext cases. So again, the people do have the concern that defendant is not a reliable source of information. What the people can confirm is that Ms. Bryant abandoned her children, the victims in this case, in an unlivable residence where several rent payments lapsed. In regards to defendant's ties to the community and the support alleged in the supplemental motion, upon information and belief, the statements that Ms. Bryant had made to the police are quite the opposite regarding her level of support. Again, she has a history of deceiving those who were attempting to support her for years. And it is difficult for me to imagine that all of her beliefs about her alleged support systems have completely changed within 2 weeks of her being in custody. And honestly, it does feel self-serving, Your Honor. The letter that was provided to strengthen her community support argument was not, again, as the court has already heard, was not from the individual who she is requesting to be released to and reside with. That individual in the letter wants to remain anonymous. How is that considered a voucher or a support for the defendant? In the letter, the individual does not make any statements about how they intend to assist the defendant if she were released, and when the last time they even spoke. That individual also admits that the defendant lied about the victim's whereabouts. They also stated the defendant knew that this individual was there if she needed help, but defendant never reached out. This is all very troubling to the people, and it is telling about the serious instability of defendant's support and her willingness to rely on that support. No one is willing to vouch for the defendant. Your Honor, in regards to defendant's potential flight risk, the people do believe the defendant is a potential flight risk with the level of local and national attention and her lack of community ties and stable housing. Most importantly, we believe that she does pose a danger to the community, specifically the victims who are members of the community, who she egregiously and intentionally neglected for years. And one other point the people want to address is the risk of reoffending. The people do believe the risk of reoffending is high here. Again, in her own statements to the police, while she was cooperating with law enforcement, defendant was not accepting or acknowledging what she did, which places a high risk of reoffending. And Your Honor, our request has always remained the same. We are requesting a high cash bail, no cash surety, no 10% provision, Your Honor.
All right, thank you. Ms. Kirindongo, this is your burden to modify the bond at this point. So any comments that are not repeating what you've already said, but anything else in conclusion to your argument?
I will try not to repeat myself, Your Honor. I just wanted to say that in regards to the bond amount or the kind of bond, quite frankly, the court would be much more assured of Ms. Bryant's appearance if the court was to do a surety bond, because it would involve potentially a bail bondsman who would also, in addition to any other supervision the court would order, would also be supervising her whereabouts. So actually asking for a cash only bond, I think on behalf of the people, for me, would be less of assurance of her, if that's what they're going to argue, of her appearing. A cash surety bond, a surety bond on the other hand would involve another party being a bail bondsman. That all being said, Your Honor, I think I provided a lot of specificities in the information that I provided to the court. Reality of it is that, you can't get this information in writing in 2 days. Nobody ever has that information when a person is being arraigned at, first arraignment date. And, again, given the level of attention this case has received, it's been difficult. The person signed their name to the letter, so the court knows who this person is. And I think everybody can appreciate, given the level of attention this case has received, why people don't want to show up on screen here with all the cameras and the news. And, I don't think that that's anything that would be abnormal. That being said, I think if the court was to follow the bond statute, Again, Ms. Bryant's bond, I don't believe should be a cash bond. It should be a recognizance bond with conditions, which as I indicated, could include a steel cuff tether, pretrial supervision, mental health treatment, drug screens. And all of those things would assure her reappearance and would also assure that the court knows where she is. So I'm asking based on that, and I think, in regards to reoffending, we know who the complaining witnesses were. I don't believe there's any risk of reoffending. The children, again, would not be in Ms. Bryant's care.
All right, thank you. At this point, the court did set this for a separate hearing in order to review whether there should be a modification of the bond. And as I indicated, the party seeking the modification had the burden of going forward with this. So the real question for the court is there a substantial reason to modify the original bond as set? Now, the purpose of the bond and pretrial release conditions are to ensure the defendant's return to court and also the protection of the public and alleged victims in the case. The purpose of the bond is certainly not to punish, even though this is an extremely high impact case. There is much interest in the outcome of this case and in the bond. But the law is very clear that with certain exceptions, a criminal defendant is entitled, as a matter of constitutional right, to have a reasonable bond or bail established for pretrial release. Cash bond is permissible if the defendant's appearance or the protection of the public cannot otherwise be assured. The court recognizes that this bond review hearing was set in a fairly short period of time, and some of the information that I requested, according to defense counsel, could not be provided within this time. I'll also note that the principal charges in this case are felonies, but not strictly assaulted crimes under the court rule. So at this point, I have reviewed all of the factors that the court is to take into consideration in determining the proper bail. The court has also reviewed the pretrial services report, and in that report, there was still a question as to the residence. However, for purposes of going forward, we will use the address that is listed on the complaint and also in the pretrial services report. In terms of the mental health concerns, the court will address that as a condition of bond. I am still not satisfied that the court can at this point say that there is a guarantee of a return to court. The defendant has not been a flight risk in the past. However, the potential penalty in this case is quite high given the nature of the charge. The protection of the public and the victims is also a concern, and I do share some of the concerns that were mentioned by the arraigning judge in terms of the defendant's potential to reach out to the alleged victims, the children in the case, to try to influence any testimony, and I'm going to deal with that issue. So I realize that there may be a need to do further review of the bond, but I do find that the court has an obligation to set a reasonable bond, and the current bond amounts to a denial of bond. So what I'm going to do is modify based on the information that we have that is verified. So I'm going to modify the bond in this case. I'm still requiring a cash bond for purposes of ensuring that the defendant returns to court to give further support to protection of the public and to prevent reoffending. But I'm going to reduce the bond to a $50,000 cash bond at this point with the following conditions. The defendant will be on pretrial services supervision. There's to be no alcohol or illegal drug use, no possession of a weapon, no assaultive conduct of any sort while this case is pending, no contact with any child under the age of 18, absolutely no contact with the alleged victims in this case. That means no contact at all, including No personal contact, phone calls, text messages, no reaching out to parties who have control of those children right now, no contact with them whatsoever. I am going to impose a home confinement electronic monitoring device. The defendant may not leave home except for medical emergencies, court appearances, court-ordered testing. And if employment can be verified, it is not verified at this point, then seeking and maintaining employment. But at this point, that has not been verified. So I don't want there to be any confusion in indicating that the defendant can go to and from work. We need verification first. Any other travel will require permission of the court. No return to the address of the alleged incident. No return to the address of the alleged victim. Any changes of address would have to be provided to the court within 24 hours. Those would be the modifications to the bond at this point. Any questions as to what the court is requiring? And I will note that Ms. Bryant, be aware that if you violate any condition of release, you would be subject to arrest without a warrant and may have your bond forfeited, revoked, new conditions imposed in addition to any other penalties if you are found in contempt of court. Any questions, Ms. Kirandongo, as to what the court is requiring?
Just a clarification, so that's still no surety?
Correct. Ms. Ferenczi, any questions?
No, Your Honor, thank you.
And if, Ms. Kirandongo, as further information is received, I know you have subpoenaed some information, you can provide that to the court. The court is willing to do an individualized review later as well. And also, if I did not indicate, a mental health evaluation and following any treatment plans as a condition of bond, since mental health conditions were reported.
So she would be able to leave in order to get that accomplished, I'm guessing, correct, even though it's not a medical emergency? It would need to be a separate, I think, exception to the home confinement.
That would have to be something that pretrial services will be further involved in.
Thank you, Anna.
All right. Thank you. Ms. Ferenczi, any questions?
No, Your Honor, thank you.
All right.
Y'all all right out there? Okay, I know you guys are a tad bit disgusted, but this is kind of how this works, where the reason why I said that the attorney was probably going to do a motion to reduce the bond is $250 million is just like saying no bond. And what was agreed upon by both sides, the prosecution and the defense, was that she's entitled to bond under our rules and under our laws of this state. And because she's entitled to bond, you cannot make, there can be a point in time of which you impose the bond of which it is so high that it's just like not giving any bond. And that's what I was saying in the prior video. And this is what Judge Walker basically said. So what she did do is, it sounds like, according to the prosecutor, they're saying that no one has money to give her bond. The defendant said it's no money to give her bond. Well, the prosecutor basically said she don't have all the support they're alleging in the community. The defense attorney said she doesn't have the money for bond. So even though $50,000, we're like, that's nothing. Will she be? It's cash. So she can't get any type of property or anything. It's cash, no surety. So she got to come up with $50,000. Now, who is going to give her this $50,000? The only thing that I'm concerned about, because based on all the information we got, if you're making $800 a month at some point, you were unemployed at the time of this incident, and we don't know how you even making your money aside from maybe getting some type of DHS or state assistance. The only thing that I don't think she personally has the money or the resources to get out on bond or to even pay for tether, because tether has a cost attached to it. But what I will say is, the way this world is right now and the way some people are weird it wouldn't shock me if somebody try to do some GoFundMe or try to raise some money or something ridiculous to try to get her out. I would be more concerned about that than the fact that she would be able to actually get this money. But this is more reachable for her. We all have to acknowledge that this is more reachable, and there's a probability, or well, I'm not going to say a probability, but a possibility that she could actually make this, you know. So yeah, that's where we at. That's where we at right now. So $250 million just got slashed basically to almost nothing, to $50,000 cash. But she can't have any alcohol, no weapons, no assaultive conduct, no contact with any kids under 18, no contact with the victims, which are her own children. She will be on home confinement if she makes bail, where she has to be on an electronic device. She can't leave her home unless she has court appearances or she has doctor's appointments. If she can actually prove that she's working. And again, it sounds like this attorney was just going off of what she said, because the attorney kept saying, oh, well, by the time we made this hearing, I didn't have time to verify anything. So as the prosecutor brought up, a lot of this is just hearsay, because it's not even connecting to pretrial services who interviewed her. And at pretrial services, I guess allegedly, according to the judge in their report, they said that she gave them information that she was unemployed at the time when she was arrested, and that she had worked some months prior to, and she had only been working for like a month at that time. So whatever she's telling this defense attorney doesn't sound like it can necessarily be corroborated, and the defense attorney didn't have time to corroborate. The prosecution is even challenging her mental health diagnosis. She's like, we don't have anything to corroborate that. The prosecution is also challenging her health issues that they're saying that she has, because the information was from Oakland County, which means she is the one that probably told them whatever health issues that she's alleging. However, I would surmise that Oakland County probably asked who her doctor was and may have gotten information. So that may be more verifiable. But the prosecution was, as you've seen, challenging everything, and was like, she's basically a terrible historian. If she is the one giving you information, then you shouldn't go off of what she says. So as it stands right now, as you heard from Your Honor, $50,000 bond is what it is, because she felt like $250 million is just like saying no bond at all. Any further questions before we get off of here? I know y'all discussed it. I know you discussed it. You said she can sell her wigs that get her $20. You know what? So where is her home? Great question. She cannot go back to the location of what would have been considered her home, but clearly she was staying with someone while her kids were someplace else. Now, who the hell she was staying with that knew she had kids and never saw her kids and they were okay with that, they need to be cussed out too. Because how you stand up in here, and I know you got 3 kids and over the last couple of years, and I don't ever see them ever, not even on the holidays, not even like these kids spent birthdays by themselves. They spent Christmases by themselves. They spent Easters by themselves, is what it sounds like. If they have not left that home in all of those years, that means that's what they did by themselves. But allegedly she was staying with someone, and she gave the address of where she was staying. And so that's where she was, but it wasn't where she has a lease at, which is where the kids were located, of which the landlord went to go check on them because she had not paid her rent in the last few months. And so went to go knock on the door and see what was up. And that's what he found, did a welfare check. That's how all of this stuff happened. So there's that. And she's giving away food to the needy, and her kids was at home starving. Yeah, that's how you know she's not wrapped too tight. Something is not, it's not clicking. I get it. Maybe it's not on paper, but you got to be a diabolical person to try to do have that type of behavior towards your own children, your own seed, your own legacy. That is crazy. She needs a complete health and medical power of attorney. That's what it sounds like to me. Them kids probably forgot about their birthdays. That is true. They probably didn't even know what time of the year it was. That is true. Who knows how long this would have gone on if she hadn't missed paying rent. That is true, Denise. And we thank God that they survived. You know, and with a whole lot of extensive therapy, they have the ability to live a productive life. Because you have what, a 15-year-old? That one's almost an adult. So she probably hates the fathers. Plan of action. Sorry, attorney. I think she got tired of being a mother. Being a mother is not for the weak, but you can't just say, would you just wake up one day and wave the white flag and you like, I don't want to do this no more. You just walk away, go to your home, your friend's house, and then you go party and you're posting all over. And then the thing was, your your family looked like on your birthday they wishing you a happy birthday. Like, so she had people, I guess, that were connected to her. So this story is just very interesting. So it'll be, hopefully she has her preliminary examination and soon, and it's not pushed back. And I'm sure it'll be televised because they're televising everything. And we're definitely going to watch the preliminary examination because then we'll see the information that they have thus far as it pertains to her in this situation. I'm going to say, like my mom used to say, let me at her. She don't look the same, does she? I'm just saying, if you guys want to know what she looked like before, go on peruse on over there to Facebook and look up Kelly Bryant. Just Google it, because everybody done talked about her and shared a lot of her pictures, and I talked about it on my first video. So, but anyway, y'all, I gotta go. I just wanted to watch this with you guys. I was actually my first time watching it. Didn't have time to watch it when it happened earlier. So I'm glad you guys hung out with me. Make sure you hit the like button, subscribe to the channel. Thank you guys for always supporting. And until next time, I'll holler at you later.